In Chapter 1 of the Personnel Rules, it talks about authority and who's responsible for which section of the rules. A&I Human Resources Division is responsible for promulgating the rules, and agencies may develop their own policies and practices that are specific for their agency. However, A&I's rules do take precedent if there's ever a disagreement between the rules and agency policy. In Section 2 of Chapter 1, the rules apply to all State of Wyoming executive branch employees, except for the University of Wyoming employees and elected officials. A&I Human Resources Division is responsible for interpreting the rules. So if there's ever a question or need clarification regarding a particular rule, A&I Human Resources Division is the agency to contact. Enforcement of the rules is actually assigned to each agency director. Agency heads or directors are responsible for the actions of their supervisors to whom they have delegated authority to act. If an agency head has delegated authority to an administrator or deputy director, that delegation needs to be placed in writing. Only written delegations of authority are enforceable under the personnel rules. In addition, employees must be informed about the personnel rules and have reasonable access to them. We've placed these rules online, and with the availability of technology these days, hopefully employees will have the ability to access rules either in their workplace or at home. Finally, employees do have a responsibility in the personnel rules to familiarize themselves with the rules and ask questions if they don't understand anything. That makes it easier if there is a question. Supervisors can address those issues up front rather than employees waiting and not being clear about a particular issue or concern. Section 6 talks about equal employment opportunity, which we'll discuss later in this section. And Section 7 refers to sexual harassment and discrimination. There is also Executive Order 2000-4, anti-discrimination, that addresses this issue also. When we discuss these topics, we'll be discussing both the personnel rules and the executive order. Executive Order 2004, anti-discrimination, was released back in 2000. It states that the State of Wyoming Executive Branch strongly disapproves of and does not tolerate any discrimination based on race, religion, color, sex or gender, national origin, age, or disability. This also includes retaliatory acts. If someone raises a complaint and then is retaliated against, that too is prohibited. Prohibited conduct under the Executive Order 2004 includes 2000-4, includes sexual harassment, ethnic slurs, racial or religious jokes or derogatory comments based on an individual's race, religion, or ethnic background, or any other verbal or physical conduct related to an individual's race, religion, sex, national origin, age, or disability. Supervisors who observe this type of conduct in their workplace must take immediate action to stop the conduct and report it as needed to Human Resources. That way we can address this situation immediately and not let inappropriate behavior continue in the workplace. Additional conduct that is prohibited includes failure to provide a reasonable accommodation to an employee who is a qualified handicapped person. This also relates to the Americans with Disabilities Act, which will also be discussed in the employment law section of this series. Basing any decisions affecting an individual's employment or any term and condition of an individual's employment on the basis of their race, color, national origin, creed, sex, age, or because the person is a qualified handicapped person is also not acceptable. Then, as most policies have, there is the catch-all of any other conduct that violates applicable discrimination law. We also have federal laws that we must comply with, which will be discussed in the employment law section. There could be conduct not addressed in this executive order, which would also be inappropriate and prohibited conduct in the workplace. Finally, retaliation against any employee who opposes a practice is prohibited by this policy. And if they've filed any type of charge, if they've testified, or assisted or participated in any manner in an investigation under this policy, that employee should not be retaliated against. And if they are, you will be held accountable for that inappropriate conduct. As supervisors, you are expected to respond to any reported or suspected occurrences of discrimination or harassment. It is extremely important that this behavior be reported and stopped immediately. If discrimination or harassment has occurred in violation of the policy, appropriate corrective action shall be taken, and that could be discipline of the offending employee up to and including dismissal. So it is important that all information regarding a harassment or discrimination concern be reported, that an investigation be conducted promptly, and that is why it is essential that you involve human resources professionals in any of these situations. These situations can sometimes be very difficult to address in the workplace. So having your human resources professional by your side working through this issue is very important to ensure that we address the behavior, stop the behavior, and correct the behavior. And finally, if we are ever called to task by an outside agency such as the Department of Labor, we would have the documentation to support us in any charge of discrimination that we might have to answer to. In addition to sexual harassment and discrimination, Chapter 1 also talks about substance abuse and the effects that it could have in the workplace. The personnel rules do prohibit conduct such as reporting to work while impaired or under the influence of illegal drugs or alcohol, and the illegal use, possession, distribution, manufacture, or sale of controlled substances in the workplace. We do not have to send employees for drug and alcohol testing to determine if impairment exists. The way we determine if impairment exists relies directly on you with the supervisor. You need to talk to the employee that you're concerned who may have reported to work under the influence. Find out if there's something going on with that employee, maybe medically. Sometimes, diabetics can have a low blood sugar attack that appears as if they're under the influence. So talking with that employee, ensuring that there's not a medical emergency occurring instead of someone reporting to work under the influence is extremely important. Once you've ruled out any medical concern, then you need to find out and document the behaviors that are of concern. Are they walking funny? Are they stumbling? Are they slurring their speech? Do you smell the presence of alcohol or an illegal substance? Some illegal substances don't have odor, but others do. So you can report any odors or unusual behavior that you're noticing. Again, I mentioned documentation. That's extremely important. You need to document what you're noticing. And when you make that documentation, ensure that you're being factual about what you're seeing. You don't want to make statements such as, oh, so-and-so's been a drunk for all the time I've known him. That would be not factual. That is an assumption on your part. So what you would want to document is the stumbling behavior, the slurred speech, and the other things I had mentioned earlier. After you document that behavior, it's always a good idea to get a second opinion from another supervisor. So for those employees that you may be concerned are under the influence, after you've talked to them, have another supervisor come in and talk to them and observe them, preferably someone who knows them and their typical behavior. That way they'll be able to document what's different about how they're behaving now versus their normal everyday behavior. Once you have that eyewitness discussion and documentation, then go ahead and contact your human resources professional. Present them with the documentation you have and ask for further guidance. Additional guidance may be to send the person home until we can determine what would be the most appropriate action. If you determine to send the employee home, it is important that they get home safely. Find a safe way for them to go home, whether it might be calling a taxi, having them calling someone that they know that could come pick them up, or even having a supervisor and another staff member returning the employee to their residence. We certainly do not want to allow any person that we suspect being under the influence to get behind the wheel of a car and drive on our highways or roads. Once we determine what to do, then we will involve the Attorney General to ensure that we are being fair and consistent in addressing this issue. So whenever you are concerned about someone reporting to work under the influence, be sure to involve your human resources professional so they can make sure we're following the appropriate processes and be compliant with the personnel rules. In addition to addressing potential substance abuse in the workplace, it is our policy to maintain a workplace free of substance abuse. So reminding employees that reporting to work or performing work for the state while impaired or under the influence of drugs or alcohol is prohibited. Sometimes it gets a little hard around the holidays when we might be out celebrating and enjoying time and not really worrying too much about work, but excesses the night before you go into work could also carry over to the next day. So reminding employees that it's just not appropriate to come to work impaired or under the influence is something that you might have to do on a sometimes regular basis. And one thing we like to do is remind folks before a holiday, hey folks, don't forget, Monday's going to come before you know it. Enjoy the holiday, but be safe and be sure to report to work, as you would be professionally on Monday or Tuesday or whatever the day may be. So in addition to the personnel rules, we have Executive Order 1990-2, which also addresses substance abuse in the workplace. And it states that it is the policy of the state of Wyoming to maintain a workplace free of substance abuse. So reporting to work or performing work for the state while impaired or under the influence of illegal drugs or alcohol is prohibited. Testing for drug or alcohol use is not required, as we've discussed previously in relation to the personnel rules, and eyewitness evidence of unusual behavior and physical signs and symptoms can be used to determine whether an employee is impaired or under the influence. So they both very much mirror each other in how we address substance abuse in the workplace. In Section 11 of Chapter 1, we go into personnel records. It is the responsibility of the state of Wyoming as your employer to track your records as an employee through personnel files. A&I Human Resources Division has access to all agency personnel records, and employee personnel records must be maintained as determined by Human Resources Division and in accordance with the state personnel records policy. There is a separate personnel records policy available online through A&I's website. It talks about when it's appropriate to allow access to personnel rules, when it's appropriate to copy rules, and how someone can go about requesting a copy of their personnel file. These all must be followed in accordance with that policy. An employee's representative may have access to an employee's personnel file upon providing a release signed by the employee. That release is available through the personnel records policy as discussed previously. Pursuant to statute, employee personnel files are confidential and can be viewed only by the employee and those employees in the chain of command.